Hello, this is Law and Terrorism, the podcast series. I'm your professor, Glenn Torres-Spelliscy. Thanks for joining me. Thanks for joining me for this week's edition of 5 Key Questions. The topic this week related to the fundamentals of international law as well as debates on how to define terrorism. So let's get started. The primary organizing principle is one of equal sovereignty. And what does that mean? It means that all nation states are considered to be equal, regardless of size, power, wealth, etc. If you are recognized as a nation state in the international system, you have the same rights and obligations as all other members. Now, from a political perspective, some states will have more power and influence than other states. From a legal perspective, however, all sovereigns are considered equal before the law. And what does it mean to be sovereign? Well, that idea has changed somewhat over time. For most of the history of the modern system, sovereignty referred to the right of a state to have exclusive control and say over its territory. What a state did inside its sovereign territory was of no concern to any other state, and other states couldn't raise questions concerning behavior. This principle began to change, however, in the aftermath of World War II. The mistreatment of its own population by the Nazi regime led to certain basic fundamental rights being articulated, rights that not even a sovereign state could ignore in its own territory. Outside of those fundamental limits, however, sovereignty still means that a state can do nearly anything that it wants within its own territory to the exclusion of all other states. We begin our exploration of international law by looking at the sources. Where does international law come from? This can be a tricky question because there is no international constitution that lays out exactly how an international law is passed. Over time, however, there are a number of different sources that have been recognized and even adopted by the International Court of Justice in Article 38. Treaties and customary law are the most important, so let's take a moment here to briefly discuss them. We'll begin with a discussion of treaties, and then in the next question, we'll look at customary law. A treaty is a legally binding agreement between two or more states to act or refrain from acting in a particular way. A state that breaches its treaty obligations and causes an injury to another state can be held accountable and be forced to make reparations to the injured state. Importantly, in a realm of sovereign equals, the decision to enter into a treaty is completely voluntary. One of the most challenging concepts in treaty law is that of a reservation. That's a legal statement by a state made when signing a treaty that basically says, although I agree to the rest of the treaty, I will not agree to this particular clause or provision, or perhaps I will interpret that clause or provision in a different manner. We will go over the concept in detail in the lecture, but for now you should be aware that when determining treaty obligations for a particular state, it is critical that you review the state's reservations to determine the extent of its obligations. Customary law is different. Customary law arises when, although there is no formal treaty, states behave in a particular manner because they believe they are legally obligated to do so. Importantly, it doesn't have to be all states, and practice doesn't need to be wholly uniform. But still, in order to be recognized as customary law, it has to be a consistent practice of most states over a long period of time. It is important to keep these principles in mind because one of the very important characteristics of customary law is that it binds all nations, except in very limited circumstances discussed in the lecture. Whether or not your state was involved in the dispute that gave rise to the finding of a customary international legal principle, once such a legal principle has been recognized, it is binding on all members of the international community. In this way, customary law is very distinct from treaty law, which only binds the signatories to the treaty. The law regarding terrorism is primarily established through treaties. Importantly, for reasons discussed at length in the lecture, there is no comprehensive treaty that outlaws all terrorist acts. Rather, there are a series of subject matter treaties that cover everything from bombings to financing. It is from these subject matter treaties that international terrorism law is largely constructed. I should also note, as we will discuss, that much of terrorism law comes from the domestic level. For the longest time, addressing terrorism was understood as a matter of criminal enforcement. so most of the laws dealing with it are domestic criminal laws. We have all heard the mantra that one person's terrorist is another's freedom fighter. What does that mean? Well, it means that in classifying a particular act as terrorist or not, perspective matters. If you are generally supportive of the cause, then you might consider the terrorist attack as a matter of freedom fighting, seeking to throw off the yoke of oppression. And indeed, international law does recognize the right of the oppressed to resist and to rebel if necessary. The question of how to draw a line between a terrorist and a freedom fighter has been the main stumbling block to a comprehensive international convention on terrorism. Well, that does it for this week's introductory podcast. Let me know if you have any questions, and I will see you next week for a new installment of 5 Key Questions.